Can the Senate summon a judicial officer over allegations of corruption? Some legal practitioners share their views. Also showing on the program, a recap of the top legal stories of the past week. In our interview segment, we chat with the chairman of the Ikeja branch of the Nigerian Bar Association, Mr. Yinka Farumbi. We look at the recent disciplinary measures by the National Judicial Council against 3 judges and some of the nation's laws in need of reforms. Hello and welcome to the program. I am Shola Shuyeli. Let's begin with the invitation or the summons extended to the Senate Committee on Ethics, Privileges and Public Petitions to the chairman of the Code of Conduct Tribunal, Mr. Danladi Umar, over allegations of corruption. Although he was later withdrawn, it remains one of the most talked about issues last week, with many people wondering, among other things, if the Senate had such powers. A non-governmental organization, Socio-Economic and Accountability Project, SERAP, and foremost human rights lawyer Femi Falana reportedly say that the Senate has no such powers to summon Mr. Umar. We also have the opinions of some lawyers on the issue.
I understand that the invitation is on allegations of corruption. And my take on it is this. If you have a genuine allegation of corruption against a serving judicial officer, there are channels of communicating this supposed corrupt practice. We have law enforcement agents. You have the EFCC. You have the police. You have the ICPC. There are so many organizations that are saddled with the responsibility of dealing with this issue. The first port of call is the police, the EFCC, and other allied law enforcement agencies. Those are the people traditionally and constitutionally and legally statutorily saddled with that responsibility. My fear is that because of the ongoing trial, it could send a negative signal that our judges are now being prohibited or intimidated by an arm of government. I don't think that's proper.
The Senate, as a part of the National Assembly, as part of the oversight functions, have the constitutional right to invite whosoever, based on petition they've received, to hear the other side. In other words, giving the person who must be accused a right of fair hearing. But that is as per it relates to their oversight functions, not more than that. In this particular case, if they've received petition, it will not be out of place to invite the chairman of the Code of Conduct Tribunal to come and answer. But what they cannot do is that they cannot sit as a court to try him. But they could, as part of our oversight function, in responding to the petition before them, invite him to give an account of what's going on. But at the end of the day, if the petition is found to have been grounded, to be okay, then the tendency is that the Senate, could then write a report to the NJC, if that is the body that oversees the tribunal or the authority that oversees the tribunal, that in view of this, they want it to be investigated.
What they are trying to do is to establish precedent, bad precedent. So if that lady is summoned and is reported, tomorrow if another officer of the Senate or member of National Assembly is being tried by the national tried by any judicial officer or is being tried, that means they can summon. They cannot be law unto themselves. They can't summon him. It's a serious danger. It's a precedent. They are laying bad precedent. It is not their function. They don't have that power. It will authorize them. And the earlier they know, the better for them.
Varying reactions there, but what do you think? Moving on now, let's check out some of the top trending stories from the courtrooms.
We begin with the report that the federal government has amended the charges of false assets declaration preferred against Senate President Bukola Saraki before the Code of Conduct Tribunal in Abuja. The amended charges, which were filed last week, contain 2 fresh counts in addition to the original 13. The additional charges include allegations that the Senate President continued to receive salaries and emoluments as governor of Kwara State after the expiration of his tenure, and at the same time from the federal government as a senator between June 2011 and October 2013. The second charge says that Senator Saraki failed to declare to the Code of Conduct Bureau on assumption of office as governor of Kwara State in 2003 his leasehold interest in the property at 42 Remi Fanikayode Street in Ikeja, Lagos. The original 13 counts comprises false assets declaration and maintaining of offshore accounts while serving as governor of Kwara State. At the tribunal where he's facing all these charges, mild drama played out last week Thursday, when the chairman of the tribunal exchanged words with one of the lawyers to the Senate President over an application asking Mr. Danladi Umar to disqualify himself from hearing the matter on grounds of bias. The situation degenerated to a level where the judge threatened Mr. Oluyede with imprisonment and ordered the police to take him away from the courtroom. Calm was, however, restored after the intervention of some lawyers in the proceedings. Staying in Abuja, this time the Federal High Court, the federal government lost its bid to conduct in secret the trial of the former National Security Advisor, Colonel Sambo Dasuki, on charges of unlawful possession of firearms and money laundering brought against him in September 2015. The court said there was no point for the witnesses in the matter to wear masks and bear pseudonames during their testimony. Justice Adeniyi Ademola, who delivered the ruling on the application for the secret trial, held that the federal government had in the charge against Dasuki listed the names and addresses of all 11 witnesses to be called to testify, and the same had already been made public. The court also held that although it has a discretion to look into issues of protection of witnesses in a criminal matter, such discretion must be judicially used only in cases where threat to life has been established by the prosecution. But in the instance case, the government failed to establish that the life of its witnesses were being threatened, and as such, no court of law will accede to such requests without established reason. The judge also turned down an application filed by Colonel Dasuki asking that the charges against him be quashed, because the federal government had continued to keep him in detention in contempt of the court. Trial was then fixed for the 18th and 19th of May. Staying with money laundering charges, another judge of the Federal High Court, Justice Okon Abeng, has fixed the 27th of April for continuation of trial in the case against the National Publicity Secretary of the People's Democratic Party, the PDP. Last week, a defense witness testified that former President Goodluck Jonathan made funds available to the defendant, Alisa Metu, for campaign purposes. The witness, Mr. Ikechukwu Abonyi, insisted that the funds given to Mr. Metu was raised by the party's campaign committee. On the 27th of April, Justice Okon Abeng will also continue with the case against the immediate past Chief of Defense Staff, Air Marshal Alex Bade. His trial was stalled last week because the judge had to attend to other issues. At the last hearing of the case, a prosecution witness, Air Commodore Salisu Yeshau, under cross-examination, admitted that most of the statements he made as evidence in court were not contained in his earlier statements to the EFCC. Counsel to the defense boss, Akin Olujimi, told the court that the witness made 5 distinct statements to the EFCC. When asked why he left out substantial parts of the evidence when he made the statement, the witness said that his statement was only based on questions he was asked at the EFCC. The defense will, however, continue their cross-examination of the witness when the case resumes next week. And we round off with the disciplinary measures meted out by the National Judicial Council, the NJC, against 3 judges. 2 of the judges from the Niger State Judiciary, Justices Idris Evuti and Justice Tanko Usman, were sanctioned for allegedly falsifying their ages. The NJC immediately suspended Justice Evuti, who is still in office, and recommended his compulsory retirement to the Niger State Governor. The council had, however, already accepted the retirement of Justice Usman effective from March 2016. The NJC also asked the Niger State government to deduct from their gratuity all illegal salaries received by both judges and remit same to the council. Another judge of the Lagos State High Court, Justice Olayinka Gbajabiamila, was also suspended from office after the council found that he delivered judgment in a matter before him 22 months after written addresses were adopted by all the parties, and 35 months after the close of evidence in the suit, contrary to the laid-down positions for same. The NJC also recommended his sack to the Lagos State Governor.